Greetings and welcome to the latest installment of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments like Seattle to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing a recent report featured on Zero Hedge entitled Downtown Seattle lost 30,000, not 13, 30,000 jobs since 2020 payroll tax, referring to the massive and ongoing exodus of companies large and small from Washington state to greener pastures and sunnier shores. I will then conclude by explaining how small and medium-sized businesses can use the same laws to their advantage to relocate out of Washington state or another jurisdiction to a new state. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Downtown Seattle lost 30,000 jobs after the city imposed a payroll tax in 2020. Bellevue, 10 miles across Lake Washington, has no such tax. The Downtown Seattle Association published the data on June 15, 2026, and stated it directly. They did not mince words. What we have seen in downtown Seattle is not a jumpstart, but instead a slow down. The so-called jumpstart tax applies to Seattle businesses with more than about $9 million in payroll expenses that also employ at least one person earning over about $194,000, $194,452 if you want to be pedantic. The tax costs those businesses between $1,450 and $9,390. Yes, correct, $9,390. You heard me correctly, per employee. In 2026, the tax is projected, emphasis on the word projected, to generate $410 million in revenue for the city. The report's finding is that the revenue came at a cost of 30,000 jobs and a transmogrification of downtown Seattle's commercial district to a near ghost town. Now, these numbers, and trends are not subtle. Downtown Seattle's office property values fell 48% between 2020 during the depths of COVID and 2025, while many other metropolitan areas were rebounding and growing. Downtown Bellevue's office property values increased 7% in the same period. Seattle's Central Business District office vacancy rate rose from 6.7% in 2019 to a whopping 32% in 2025. Those are foreclosure numbers for the owners of skyscrapers. 32% is not sustainable. Bellevue's rose from 2.5% to 24%. Both cities experienced post-pandemic disruption, but only one of them imposed a payroll tax on top of it to add insult to injury. The city that imposed the tax lost half the value of its office district. Yes, you heard that correctly. And the city did not gain value. Seattle's property tax rate per $1,000 of property value increased 48% from $3.79 in 2019 to $5.60 in 2026. Meanwhile, Bellevue's decreased 19% from $3.72 to $3.12. The report's conclusion is blunt. Seattle has become a tax outlier in the region, and it is costing the city jobs and tax revenue while shifting the property tax burden to residents and small businesses, thereby worsening the affordability crisis. Now, Amazon is still headquartered in Seattle, last time I checked. It has been expanding, however, in Bellevue since 2017, growing from 450 employees there to more than 15,000. Amazon committed $100 million to affordable housing in Bellevue and $22.6 million for local transportation projects. The investment is going to Bellevue, not to Seattle. The jobs are also going to Bellevue. And the tax revenue that follows jobs and investment is going there as well. Seattle imposed the tax and received $410 million per year, but it lost 30,000 jobs, half the value of its office district, and its largest employer is building its future 10 miles east. This is the same pattern that plays out at the state level, compressed into a single metropolitan area, where the only variable that changed was the jump start payroll tax. As reported on earlier editions of this podcast, Legal Bites, Washington State ranks in an abysmal 45th place on the Tax Foundation's most recent state tax competitiveness index. It imposed an almost 10% capital gains tax. It raised its state level estate tax to 35%, the highest of any state. Jeff Bezos left for Florida. Howard Schultz also left for Florida. Gabe Newell of Steam fame purchased a $70.8 million estate in Florida. You sense the trend. The state level departures and the city level departures are driven by similar calculations. The cost of remaining exceeded the cost of leaving. For business owners in Seattle specifically and in Washington State generally, the Jumpstart data provide a controlled experiment. Two cities, same labor market, same geography, same economy. One imposed a payroll tax and the other did not. 5 years later, one lost 30,000 jobs and half its commercial property values, while the other gained jobs, gained investment, and cut its property tax rate. The experiment has been completed and the results are in. With this context in mind, redomestication is the lesser known legal process of transferring a company's legal state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income taxes, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. All of that to say there is zero operational or financial disruption, but only if you get it right the first time. That is why it is imperative to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, yes, including Washington, and for limited liability companies, partnerships, sub-S entities, and subchapter C corporations. So if someone is telling you it cannot be done, what they are really telling you is that they do not know how to do it. Now, foreign entity registration is simply not the same thing as redomestication, because foreign entity registration, also referred to as foreign qualification, does not change the company's domicile. In fact, it does the opposite by keeping the entity in that former state indefinitely and merely adding another layer of compliance and tax obligations in the destination jurisdiction, leaving you anchored to the state you were trying to leave. Meanwhile, a traditional merger, which is also not the same thing as redomestication, creates a new distinct entity in the destination state, may require the issuance of a new federal employer identification number, and can trigger serious tax consequences. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. Dissolution is a going out of business event, not a relocation mechanism. And to make matters worse, and believe me, it gets a lot worse, dissolution is often a taxable event, and when performed incorrectly, can expose the owners of the company to unlimited personal, yes, you heard me right, personal, joint and several liability for the company's liabilities, known and unknown. That is because the so called veil of protection no longer exists because the company no longer exists itself. Think about that. The logic is straightforward. If you think dissolution is a cost cutting mechanism, you may be in for a rude awakening. And if you have a so called professional suggesting dissolution as a relocation strategy, please seek better advice. Redomestication, when paired with a change of personal residency and this is an important and, a reduction or outright cessation of business operations in the former state can reduce or even eliminate state tax nexus exposure there for the entity and its owners. Don't take my word for it, ask your CPA. And if you get a blank stare from your CPA, well, it might be time to work with someone more experienced. Now is the time to consider acting before the Washington legislature considers changes to the law to hinder or even eliminate the possibility of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of Washington or out of another state, please use the link in the description for more information on this intricate process and to schedule time for you and I to speak one-on-one about your specific situation. Again, my name is Chad Daniel Cummings of the firm Cummings and Cummings Law, and I hope that you found this information informative. As always, this information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these tantalizing and timely topics, or at least I think they're interesting, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.